Imagine a company building a new factory. The factory must open by a specific date. If it opens late, the company loses sales. The builders finish the factory 3 months late. The company loses a lot of money. How much should the builders pay for this delay? Without an agreement, this leads to big problems. Long court cases can be very expensive for everyone. Contracts are promises between people or businesses. Sometimes these promises are unfortunately broken. This is called a breach of contract. A breach can cause significant harm to one party. It is wise to plan for such possibilities. Parties should think about what happens if things go wrong. This planning helps manage risks effectively. Liquidated damages clauses offer a solution here. They set a specific sum of money for a breach. This avoids arguments about compensation later. Understanding these clauses is vital for sound contracts. Liquidated damages are a sum of money. This sum is agreed by both parties in a contract. It is agreed before any problem happens. It is paid if one party breaks a specific part of the contract. This breach is usually clearly defined. For instance, it could be failing to finish a project on time. The amount is fixed in advance. This makes the consequence of a breach clear. This sum is a genuine pre-estimate of loss. It aims to compensate the innocent party fairly. The goal is to cover the actual harm expected. It should reflect the probable financial impact. The main purpose is to create certainty. Both sides know the financial outcome of a specific breach. This helps to avoid costly legal battles later. Liquidated damages simplify this entire process. Compensation becomes more straightforward. This saves both time and valuable resources. Liquidated damages are for compensation. They aim to cover the actual loss suffered. The sum is a fair estimate made in advance. It helps the innocent party recover their losses. It is not designed to scare the other party. The focus is on fairness and realistic estimation. This makes the contract more balanced. A penalty clause is very different. Its main purpose is to punish a party. The sum in a penalty clause is often very high. Courts do not like penalty clauses. They see them as unfair and oppressive. Courts look very carefully at these clauses. They check if the sum is a genuine pre-estimate, or if it is designed to be a threat. If the sum is excessive, it looks like a penalty. This means it is out of proportion to any possible loss, so making it a genuine estimate is vital. One major benefit is certainty. Both parties know the cost of a specific breach. This knowledge is available from the start. It helps in planning business activities. It also helps in assessing contractual risks. There are no surprises about the amount of compensation. This predictability is valuable in commerce. Liquidated damages save time and money. Proving actual loss in court is often expensive. It involves lawyers, evidence, and court fees. This process can take many months or even years. A liquidated damages clause avoids this. The amount is already agreed. Disputes about the sum are less likely. This leads to quicker and cheaper resolutions. Recovering losses becomes much easier. The innocent party does not need to prove their exact financial harm. This simplifies the claim process considerably. The construction industry uses these clauses often. Delays in building projects are quite common. These delays can cause large financial losses. For example, a client might lose rental income or they might face increased costs for alternative premises. Liquidated damages for late completion are standard. They provide a clear remedy for such delays. Information technology projects also benefit greatly. This includes software development and system installations. Delays in IT projects can disrupt business operations. Clauses can cover late delivery of software. They can also cover failure to meet performance targets. Manufacturing and supply agreements frequently include them. Businesses rely on timely delivery of materials. If a supplier is late, production lines might stop. Liquidated damages can cover these kinds of disruptions. Event management is another key area. Many suppliers provide essential goods and services. Liquidated damages offer some financial protection. The main test is whether the sum is a genuine pre-estimate of loss. Courts look at this from the time the contract was made. They do not assess it at the time of the breach. The question is, was the sum a reasonable forecast then? It must not be an arbitrary figure. It should be based on a thoughtful assessment. This is the cornerstone of enforceability. Parties should keep records of how they calculated the sum. Courts will ask if the sum is extravagant and unconscionable. This means, is it far too high compared to any possible loss? If the sum seems designed to frighten, it is likely a penalty. A penalty is intended to punish, not to compensate. The court compares the agreed sum with the greatest loss. This is the loss that could realistically happen from that breach. If there is a big difference, the clause may fail. The clause must be commercially justifiable. Difficulty in pre-estimating loss can help. If it is very hard to calculate the exact loss in advance, then a reasonable agreed sum is more likely to be upheld. The words used in the clause are considered. However, they are not the deciding factor. Consider a property developer building new homes. They promise to finish by December 1st. The contract states liquidated damages of £200 per house per week of delay. This sum represents lost rental income for the buyer. Or it could cover costs of temporary housing. If the developer is 4 weeks late on 10 houses, they would owe a pre-agreed amount. This avoids complex calculations of individual losses. Think about a city hiring a company for road repairs. The repairs must finish before a major marathon. If the road is not ready, the marathon route must change. This causes huge disruption and extra costs. The contract includes liquidated damages for each day of delay. This sum considers costs like replanning and public notices. It provides the city with clear compensation. A famous legal case is Dunlop Pneumatic Tire Co. Limited v. New Garage and Motor Co. Limited. This case from 1915 helped define the rules. The court said this was liquidated damages, not a penalty. The sum was a fair attempt to estimate this complex damage. Always ensure the sum is a genuine pre-estimate of loss. Keep records of how you calculated this figure. Write down the types of losses you considered. For example, lost profits, extra rental costs, or wasted expenditure. This documentation can be very important. It shows you made a serious effort to be fair. It helps prove the clause is not a penalty. Be very specific about the breach that triggers the clause. Do not use vague language. Clearly define the exact event or failure. For instance, failure to achieve practical completion by the completion date, or failure to deliver the goods by the delivery date. Avoid general phrases like any breach of contract. The clause should apply to a particular identifiable obligation. Use clear and simple language in the clause. Avoid complex legal jargon if possible. Everyone involved should understand what it means. This reduces the chance of it being challenged. Liquidated damages are a very useful tool in contracts. They act as a contractual safety net. They provide certainty when contractual promises are broken. This helps businesses manage risk effectively. They can save both time and money. This is because they avoid lengthy disputes about compensation. Their role in modern commerce is significant. They help make business dealings more predictable. The difference between liquidated damages and penalties is vital. A clause must be a genuine pre-estimate of likely loss. It should not be designed to punish the breaching party. Fairness is the guiding principle here. Courts will not enforce a clause that is unfair or oppressive. Understanding this distinction is key to drafting valid clauses. The aim is always compensation, not a windfall. This maintains the integrity of the contractual remedy. Careful drafting of these clauses is absolutely essential. A well-written clause protects the interests of both parties.